Garcia versus Court of Appeals. The facts of the case are as follows. On March 30, 1998, complainant Aquilino Pimentel filed a case before the Regional Trial Court of Alaminos against Herminio Romero, Renato Viray, Rachel Palisok, Francisco de Vera, and Arsenia Garcia for violation of Republic Act No. 6646, Section 27B. Allegedly, the members of the Municipal Board of Canvassers, who are the accused in this case, conspired with, confederated together, and mutually helped each other to unlawfully decrease the votes received by senatorial candidate Aquilino Pimentel Jr. from 6,998 votes to 1,921 votes, as reflected in the statement of votes by precincts with serial number 008423 and certificate of canvass with serial number 436156 with a difference of 5,077 votes. The Regional Trial Court acquitted all the accused for insufficiency of evidence, except petitioner Arsenia Garcia, who was convicted for the violation of the election offense and is thus sentenced to suffer an imprisonment of 6 years as maximum. But applying the indeterminate sentence law, the minimum penalty is the next degree lower, which is 6 months. However, accused Arsenia Garcia is not entitled to probation, disqualification to hold public office, as she is also deprived of her right of suffrage. Garcia appealed before the Court of Appeals, which affirmed with modification the Regional Trial Court decision, increasing the minimum penalty imposed by the trial court from 6 months to 1 year. Petitioner contends that there is an erroneous judgment considering that there is lack of substantial evidence against her and that she has no motive on her part to reduce the votes of the complainant. Respondent contends that good faith is not a defense in the violation of an election law, which falls under the class of mala prohibita. The issue in this case is whether or not violation of Section 27B of Republic Act No. 6646 classified under mala in se or mala prohibita. The Supreme Court ruled that violation of Section 27B of Republic Act No. 6646 is mala in se because the acts complained of is inherently immoral. Mala in se felonies are defined and penalized in the Revised Penal Code. When the acts complained of are inherently immoral, they are deemed mala in se, even if they are punished by a special law. Accordingly, criminal intent must be clearly established with the other elements of the crime, otherwise, no crime is committed. On the other hand, in crimes that are mala prohibita, the criminal acts are not inherently immoral but become punishable only because the law says they are forbidden. With these crimes, the sole issue is whether the law has been violated. Criminal intent is not necessary where the acts are prohibited for reasons of public policy. Violation of Section 27B of Republic Act No. 6646 is mala in se. Generally, mala in se felonies are defined and penalized in the Revised Penal Code. However, when the acts complained of are inherently immoral, they are deemed mala in se, even if they are punished by a special penal law. Intentionally increasing or decreasing the number of votes received by a candidate is inherently immoral, since it is done with malice and intent to injure another. Criminal intent is presumed to exist on the part of the person who executes an act which the law punishes, unless the contrary shall appear. As applied to the case, the grand total of the votes for private complainant Senator Aquilino Pimentel was only 1,921 instead of 6,921 or 5,000 votes less than the number of votes private complainant actually received. Petitioner admitted that she was indeed the one who announced the figure of 1,921, which was subsequently entered by then accused Viray in his capacity as secretary of the board. This error was also evident in the certificate of canvass, COC number 436156 signed by petitioner Viray and Romero. The discrepancy may be validly attributed to mistake or error due to fatigue. However, a decrease of 5,000 votes as reflected in the statement of votes and certificate of canvass is substantial. It cannot be allowed to remain on record unchallenged, especially when the error results from the mere transfer of total votes from one document to another.